All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in Tauscher versus Hanshew, our case number CV150661 Each side is allocated 20 minutes for oral argument. If appellant wishes to save a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask those in attendance to make sure that your phones are off so presentations are not interrupted. We've read the briefs. We've conferenced the matter. We're familiar with the record. We'd encourage you to keep that in mind during oral argument today. Oral argument also is being recorded and will be posted to the court's website and then to YouTube in due course. So please, as you begin your argument, state your name and the party that you represent. With that, Ms. Vogel, you may proceed.
Good afternoon. I'm Lori Vopel, counsel for the mother in this matter, Jacqueline Tauscher. The trial court in this case erred and abused its discretion by failing to fulfill its duties under ARS 25317B and under SHARP by failing to both ensure that this agreement, when it was finally put into writing, a full draft, a full writing, accurately reflected the understanding of the parties and was fair and equitable.
Well, should the court have just waited until the final decree was sent before finding that the parties had resolved it based upon their comments at the original hearing, that it's what they wanted to do in lieu of a trial?
Your Honor, normally under Rule 69, and that's one thing that we pointed out here, and one point that counsel for mother was trying to point out, even the judge was calling the what he was accepted as a Rule 69 agreement bare bones. It basically was a handwritten scratch of notes of, that was scriven, by one of the attorneys for the father. Rule 69 and Rule 80 actually contemplate, when Rule 80 is what it's based on, that it be a signed writing or that the terms of the agreement be orally set forth in court. And that didn't happen here. And so...
But doesn't it also allow that if both parties under oath say it's their agreement, then it's their agreement?
Your Honor, but it wasn't yet in the final form. And if you look at SHARP, the same thing virtually happened. You had a handwritten agreement there, and the judge basically, and the court actually said that it was incumbent upon the trial court to ensure that to still fulfill essentially its duties under 25317 to ensure it was fair and equitable. There were ambiguities when it was finally put into the writing, and Ms. Tauscher immediately said, look, this is wrong, this is inaccurate, or this is not clear. And if you look at the case that I cited, actually under Rule 80, the Lions Enterprises case, there the court refused to enforce what had been designated as a Rule 80 agreement when one party would not sign the final settlement agreement due to misunderstandings regarding its terms, and where those final terms were not put in a signed writing or placed on the record. So here you do have some room for ambiguities. There's a problem, I think, with the way that the judge received this, but ultimately, even if you assume it was a valid Rule 69 agreement, Rule 69 states, it doesn't say foreclose forever any kind of challenge. What Rule 69 says is that the court is that there is a presumption of validity that operates, and that the party challenging it has the burden to prove any defect. And above and beyond that, it says that the trial court still has the duty to ensure that it's fair and equitable pursuant to ARS 25-317. So this isn't some ironclad whatever father put together, whatever his father, they put together just because they said on the record, yes, it's our understanding. When it was finally reduced to an actual writing for signature, the mother said, wait a minute.
So
This isn't what I agreed to.
Well, is that what the rule contemplates, that the challenge would occur through sort of competing arguments about what the notice of lodging of judgment, when you file the notice of lodging of judgment and you fight over the T's and the I's aren't dotted correctly and the T's aren't crossed, is that what's contemplated as a challenge, or is it something like a motion to set aside the agreement on the grounds of mistake, fraud, misrepresentation, et cetera?
Your Honor, I think that here, regardless of a valid and binding agreement, even if you treat it as a contract, there has to be a meeting of the minds. There has to be mutual assent and no mutual mistake. And what happened here is this doesn't even contain complete sentences. Okay, these are scribbles, and there was a page missing from the property inventory, which ended up being one of the issues that included the inventory of father's firearms and the actual value of it, which, when it was scrivened here, was valued at half of that amount. So instead of almost $10,000, it was valued at, less than $5,000, and that she was then to get half of that. And then there were other questions that, regardless of the validity, have to do with the bigger picture as well of the trial court's duty under the statute and under Sharp to ensure that it ascertains the full content of the marital estate, what is community, what is separate property, and ensures that both parties, including the challenging parent, has a full understanding of that. She came forward and said, look, under the agreement, just for example, the father was required to fund the children's education accounts. That was his separate obligation. And he was required to advance me $10,000 for the moving. And then there were, various calculations and, other give and take in the agreement to make up for that. What happened then is that it wasn't clear. The mother became, aware that money was being taken out of and checks were being written from the home equity line of credit that indicated, for which she was 50% responsible then. And that changes the equation, and the judge should have ensured that, and they repeatedly asked for those disclosures to make sure that wasn't happening, because the agreement is contemplating that he is to fund those from separate property, not the community. The same with the attorney's fees issue.
Let me ask before you get to that.
Okay.
Under your view of 69, when would a trial court ever invoke or allow 69 to be invoked, if it's sort of an opening offer as opposed to a statute of frauds?
Rule 69 contemplates, and again, you have a situation here that I think is different from what Rule 69 contemplates. If the judge would have had literally set forth the terms of the agreement, not just said, did you come to an agreement, but literally set forth the terms of the agreement. For example, like what happened at the April hearing. The specific terms were set forth on the record. And if you look at these other cases, they really set forth the terms of the agreement on the record. That wasn't done here, and there wasn't a signed writing. So you have already some real ambiguity in this proceeding that is ripe for confusion. And she had a right.
I understand your point, but you're saying it only provides a presumption of a validity.
It does.
And then allocates the burden of proof to challenge it.
Correct.
For a busy family court judge who could spend X amount of time, making the perfect record are trying to, on a settlement agreement that the parties in at least some critical respects have committed to writing, or could go forward with trial, why would the trial court ever try to work through the settlement agreement under your view of how 69 should work?
Because that's what Rule 69 requires, because you're talking about, because it is presumed valid, Your Honor, it does have specific requirements that it be a signed writing, and Rule 80 operates the same way, Judge. I mean, that's the rule that Rule 69 is based on, and so you could call it.
And that, but you're describing a rule that seems quite different than my understanding of Rule 80.
Right. I think this
I'm-
is more subject to challenge, to be honest. I think Rule 69 is more subject to challenge because it's not, doesn't say it is valid and binding, it said it is presumed. And that instead of under a normal situation where the party is trying to prove the validity of a dissolution, a settlement agreement, a dissolution proceeding where that party has the burden, now it's the person who's challenging it. So there is a higher threshold, Judge, to do that. Here you have a situation where it wasn't even put into a signed writing yet, and she said, whoa, whoa, whoa. And she has a right to say that there are some problems and discrepancies here that need to be cleared up. And frankly, they were there in court. Her counsel, who was her original counsel, was ready with the evidence, with the paperwork to show the judge they could have resolved this in a fairly short order of time with being able to show that and the judge asking questions of father's counsel and trying to resolve these just to help ensure that, yes, this is fair and equitable. That's his duty, Judge.
Well,
and
I
even Rule
understand-
69
I understand
says
your
that.
perspective, but I think from the trial judge's perspective, he might have reasonably believed that's exactly what he did.
Well, no, Your Honor, and I think if you look through the transcript, and I quoted large parts of it in my opening brief, he said he essentially just agreed with father's counsel and said, we're not going to relitigate this. So what he did was he had signed, actually, when new counsel came in, she did a red line immediately to show, look, the day after she was re-retained.
So after the date set for trial? Sometime
After the
that.
date, yes, set for trial. And so
I understand a lot was done after that. My focus, at least initially and primarily, is that specific day.
And, Your Honor, there were discussions. And again, the time, they had a lot of time constraints. They all had time constraints, the family court and the parties and their lawyers and they were trying to settle this in good faith. And she believed, that what they had written down, and the lawyers were basically putting it together, the attorneys with their clients. But once it was finally put together, it wasn't laid out and it wasn't ever written. I think that the judge, frankly, said this is a Rule 69 agreement prematurely because it really these were scrivened. And then the father's counsel is also the one who then translated that and put it into the settlement agreement. And there were questions. There weren't a massive number of questions here, but there were questions that needed to be answered, clarifications that needed to be made, that the trial judge always, whether it's a Rule 69 agreement or not, that's what Rule 69 says, and Sharp says, that is the trial judge's duty to take the time to ascertain.
Counsel doesn't have a role in all this?
I think, yes, counsel does have a role in that, and that's where initially she went to her lawyer when he showed it to her, and she said, I've got some issues here.
And it seems that the thing that I'm pushing, as you get a feel for, is it seems to me the time for mother to raise objections was on the day of trial. And if she says, no, I don't understand this, or no, I have concerns about this, or no, I didn't agree to that, I'm sort of guessing that this trial judge would have said, okay, let's call your first witness. I mean, it would have been one or the other. It
Judge,
wouldn't have been, we'll defer trial for another time, and that's what I struggle with.
What I'm laying out here, Judge, though, are both Sharp and the rule say This is how you treat agreements. This is how you treat the agreements of the party. So once you have the agreement, then you need to look at it. And the judge is required, per Sharp, per Rule 69, to make sure it's fair and equitable, to make sure it accurately reflects the understanding of both parties. And that's also general contract law. It's not that, okay, well, whatever father comes up with, mother's supposed to sign.
Also not the obligation to eradicate all possible ambiguities. That could never happen. 69 would cease to exist if that's the
I don't think they were asking, Your Honor, to eradicate the entire agreement.
No,
there were
ambiguities.
specifics.
I mean,
yes, and there were specific ambiguities that could have been answered here, like we said that the parties were to pay their own attorney's fees. Why it looks like he paid these, put it on a credit card for which mother is now 50% responsible, or at least even if he was made responsible for it, it was factored into, the ultimate equalization, and payment on, that came out of the home equity line of credit. That could have been answered, Judge. That could have been resolved. And in fact, her new counsel, tried to resolve that in advance of the hearing in May, to just say, where did this, where did it come from to pay for for the attorney's fees? And how do I know that he paid his own attorney's fees? Because it looks like it came out of the home equity line that now I'm 50% responsible for. How about the children's education funds? We just need to know, do you have some, you can show me that it actually came from his separate property, because otherwise I'm paying for half of that too. And all of these were factored, into an equalization payment. So she had a right to ensure that this was, that her understanding, his understanding, that they were on the same page, and to have some of these basic questions answered so that they could ensure that it was fair and equitable. That's the trial court's job under the statute, under Rule 69, and under Sharp with respect to a final agreement, including a final Rule 69 agreement, Judge. He still has that duty, and he did not do that here. And Sharp says the judge is required, once there's a challenge, to receive evidence and to look at that.
Well, but Sharp was a motion for summary judgment, okay? And so there was a different standard that applied when there was a challenge to what the agreement was. Here there's a 69, there's new counsel, there's a consideration of the terms, but, how are we to look at the requirement of the trial judge when both parties, under oath, said, this is my agreement, and I want to enter into it, and I don't want a trial today?
Because this was the agreement. Because it's
It could be
scriven.
on one page.
Right.
Okay? And if they say, that's the page, and we agree to it, okay, you don't need more.
Then those notes are then put into a fuller writing by one party's counsel. The other party always has a right to look at that and say, no, that's not how I interpret what we wrote, what you guys wrote down here and what we agreed to. They absolutely always have that right. This was not a signed agreement, nor were the terms specifically set forth on the record. That's what Rule 69 contemplates. And so what I'm saying here is that the judge has an overarching duty. It's a statutory duty, and it's not just Sharp that says this in the posture of a motion for summary judgment. That was filed because they refused to sign the final agreement. But if you look, there's a long line of cases, the Simpson case, the Wiggs case, numerous cases that we cited that all go back and say this is the trial judge's duty. And it is the trial court's duty to ensure pursuant to it. And in fact, if they couldn't ever consider evidence, then why would Rule 69 itself both say that the judge still has this duty under statute and that the party challenging it has the burden to prove? That contemplates the ability to say, no, there's some problems here, And I get to show you what, Judge, and you need to receive it and consider it. I'd like to save the rest of my time for rebuttal.
Thank you, Ms. Wolf. Ms. Feldman.
Good afternoon. My name is Elizabeth Feldman, and I represent Father, the appellee in this case, Eric Hanshew. This case is about two parties who were well represented in trial and entered into a valid and binding Rule 69 agreement, scribbled somewhat handwritten, not repeated on the record. However, what was done was very, very clear. On August 26, 2014, the court allowed the parties and encouraged the parties to negotiate a settlement. We presented a joint pretrial where we agreed on A, B, and C, and we just agreed on E, F, and G, if I'm forgetting the number or letter. And the judge said, do you want more time? Do you want to negotiate? We all negotiated. And you can tell from the transcript that we negotiated from prior to lunch through part of the afternoon. And we ended up with a handwritten note. There has never been an allegation that anything untoward happened with that note or those scribbled pages. Those pages were then presented to the judge, where the judge went through the litany that I guess all trial courts do, or every trial court that I've seen. Are you familiar with the document? Does it represent the agreements that you've reached? Do you understand all of those agreements? And are these agreements of your own free will and not pursuant to any threats or duress? And to all of those questions, Mother answered yes. The judge adopted that agreement and then instructed the parties to do documents that reflected those agreements. Mother is now complaining and made all of these complaints to the trial court. And Mother's complaints to the trial court resulted in another hearing, which was almost an hour and a half long, on May 20th, 2015, where every single issue that's raised today, whether it's the HELOC or the attorney's fees or the guns or whatever, every single one was raised and debated. And although it was not an evidentiary hearing, I've called it a hybrid hearing for lack of a better term, that trial court heard all of the attorneys, including her last attorney, who was her first attorney, and the parties. That trial judge asked both parties questions during that hearing. All of those arguments were made, and the trial court fashioned a decree and made certain provisions that we were to follow. Mother's arguing that the trial court did not verify the accuracy of the Rule 69. I do agree that the trial court has the discretion to do that, but I think that they did that in that hybrid hearing in May 2015. And in fact, one of the big arguments that Mother raises now is the math. Well, the math was done during that hearing.
Counsel, you don't dispute that there were ambiguities or things that could have and should have been covered more clearly in the original hearing.
I don't dispute that there are ambiguities. I have never seen a Rule 69 that did not have ambiguities. I think that's the risk that we all run.
In fact, it contemplates the challenges. Obviously, it contemplates that a party can file a challenge, although that party would bear the burden under the rule.
The rule, yes,
aside.
I agree. And I think that was done in that May 2015 hearing. The only thing that wasn't done in that May 2015 hearing is, quote, evidence taken, or...
But how would the court, let me just give you an example. How would the court do this without evidence? How would the court resolve the issue regarding the $10,000 advance payment? Was there supposed to be a $10,000 advance payment to
Yes.
To mother?
And
then
actually-
how would the court resolve that with no evidence showing where those funds were going to come from? Because obviously, if it came from community funds, then there's no benefit to her.
Well, and with all due respect, that might not be the best example because there's no way it could have come from community. That advance was agreed to as of the trial date of August 26, 2014. So as of that date, there was no more community. So whether or not he took the funds out of the HELOC, which he was then taking responsibility for, or a credit card that they were both had previously been using, it became his responsibility as of the date of service on some things and as of the date of trial on other things. So there was no way. But other ambiguities could and may be in other cases, or maybe something here, need evidence. In this case, there
Vehicles.
aren't.
I mean, like the vehicle, the value of the vehicles, could that fairly be resolved without taking evidence?
In another case, no, I think you would need evidence, but I think then the party that has the burden should have requested an evidentiary hearing. And I think that's one of the really interesting issues of this case that wasn't raised, is this hybrid hearing. Should something have different been done? And I'm certainly not a legal scholar, and I don't profess to be, but that wasn't asked for. So our, quote, objections at that hearing were, if you're going to present evidence, we get to too. We get to know that you're going to present evidence. We get to cross-examine your evidence. We get to review it. We get to, call our own witnesses. We get to do Blue Book. You get to do Edmonds, whatever it is. And that didn't happen, but all the parties got to talk. And Mother never, ever filed any request. Interestingly, Mother never filed a request for an evidentiary hearing, and Mother never ever disputed until we got here today that she didn't have this information. She would continually ask for the information. It was continually supplied, but there was no formal request. After that date of trial, there were no formal requests for discovery. There were no motions to compel. There were no subpoenas.
Is there a typical way? Is there a typical, in practice, how a party goes about raising an evidentiary challenge to a Rule 69 agreement?
Well, I think it's an oxymoron to say typical in family court, but the way I would typically do it is that...
Then there isn't one. Okay, then there isn't.
But you get to avail yourself of all the informal and formal ways that are provided in the rules and in practice and procedure, which is you ask for that information. If you can't get it or you don't get it for whatever reason, you can formally request it from a third party with a subpoena. If you still don't get it or that's not the available way to do it, you ask the court in a motion to compel. And in fact, in this case, also the interesting part, and I think maybe this is one of the issues with having different counsel argue an appellate issue versus a trial court issue, is if you look at...
Well, it's not an issue because anyone can,
Of course.
It's a non-issue.
Okay, fair enough. My point is, in the joint pretrial statement, there's a statement that both parties agree that there's no further discovery to be done. So all the discovery was out there. They had every piece of information that they needed at the time of trial. And after trial, they didn't need anything else. I think it's interesting that, and the perfect example of that is this gun issue that Mother raises now. Mother raises this issue, and we heard it today, that the guns were half. Well, if the joint pretrial that Mother's counsel submitted, both counsels submitted, it agreed and it specified that the guns were 4,500-ish versus 9,000. So now we're making another argument that is exactly contrary to what was already stated in the record. Mother makes an argument today that the Rule 69 agreement wasn't a Rule 69 at all because it wasn't recited by the court. There's no provision for that. And I think in this case, the fact that Mother at the end of her appellate argument asked for remand for reevaluation of the Rule 69. To me, that's an admission that she does believe that there was a Rule 69 and that it was binding and that she understood it. And I request that this court respectfully find that the trial court's entry of the decree was fair and equitable, that Mother had accurate knowledge of what was contained in the agreement, and the trial court did ensure that it was fair and equitable through both the August 2014 hearing and the May 2015 hearing. And
So we need not rely just on the first hearing, but on both of the hearings to address the challenge.
yes, sir.
Okay.
The second hearing took well over an hour, and the judge went through every single issue, and everybody had the opportunity to speak. The only thing that the parties didn't have was the opportunity to present evidence, and that's because Mother, who had the burden of challenging it, didn't ask. Thank you.
Thank you, counsel. Ms. Volpe, you have the last word.
Thank you. Just very briefly, to answer the last point first, actually Rule 69 says that the agreement must be in writing or the terms of the agreement must be set forth. And it's clear from the cases interpreting this and the rule it's patterned after that that means laying out the terms, not just asking, is this agreement your agreement, unless it's a signed written agreement. As for the position that every issue was raised and debated, at every single juncture here, counsel for father took the position that you cannot relitigate this. You cannot get into this, judge. You cannot consider this. This was not a hybrid hearing. What this was is the judge had, perhaps unknowingly, unwittingly, had signed the mother's proposed consent decree. This resulted from a motion, father's motion, to set aside a signed, entered judgment and decree. Frankly, the burden was on father's attorney, or father to show why that was a problem. What the judge did here instead was he said, okay, give me your agreement. I'm going to look at your proposed agreement, and I'm going to look at mother's proposed agreement and decide what we're going to do here. But instead of receiving evidence to ensure that both parties' understanding of the agreement was in that final decree, basically he agreed with father's attorney that they had to just look back at these handwritten notes and go along with what father's version was. That's what happened at every single juncture. And at a hearing, she didn't have to request that. This was essentially a hearing on a motion to set aside, and it was totally appropriate in any context for the judge and incumbent on him to ensure that this was accurate, that it reflected both parties' understanding, and that it was fair and equitable. Thank you.
Thank you. Counsel, we appreciate your argument today. We appreciate your briefing. You've given us much to think about. We will take the matter under advisement. We'll issue a written ruling in due course. Thank you. We stand adjourned.